Hello and welcome to Unacademy. Yesterday, the Union Home Minister introduced an interesting constitutional amendment bill in the Lok Sabha, which seeks to address one growing concern: the criminalization of Indian politics. In this video, we will discuss what are the provisions of this bill, why this law may be needed, what are the concerns, what if once enacted, this law is misused, and then, is this a red herring, a distraction? Maybe we need to focus on something else, but we are made to focus on something completely different. Let's get started. But first up, let's look at what are the provisions of this bill. This bill seeks to amend various provisions of Indian Constitution, such as Articles 75, 164, 239 AA, which deals with Council of Ministers at the union level, at the state level, and in union territories. What is the provision? If I am a minister at the union level, but now I am arrested and I am in custody for 30 days, on what charges? If these charges are proven and I am convicted, I will be imprisoned for 5 years or more, which means if I am a minister appointed by the president on the advice of the prime minister, but now I am arrested and I'm in custody for 30 days. On what charges? If these charges are proven, I may be convicted and imprisoned for 5 years or more. Then on the 31st day, because I'm in custody for 30 days, then on the 31st day, Prime Minister will have to advise the President, remove me. But if he doesn't, then on the next day, I will automatically cease to remain a minister. And this applies to a minister at the union, a minister at the state, a minister in a union territory, chief ministers as well, prime minister as well. But once I'm released, I can be reappointed as a minister. Why this law is required? Look at Association for Democratic Reforms, a non-governmental organization which is working in the field of electoral reforms in this country. According to their report, 46% of the MPs elected to 18th Lok Sabha, the current Lok Sabha, they have criminal charges against them. Not just that, 31% are charged with serious criminal offenses: rape, murder, offenses against women. What about 17th Lok Sabha? This percentage was 43. Now it is 46. That means it's a growing concern. You may have heard about Lord Acton. He once said, power corrupts, and absolute power corrupts absolutely. George Bernard Shaw, he says, power doesn't corrupt men. Fools, however, once they get into the position of power, they corrupt power. Look at Nash equilibrium. For example, you are participating in a game. There are various participants. If only you will change your rules of the game, it may not benefit you much unless and until others also change the rules of the game. Which means if you are changing the rules of the game, only you, but others are keeping their strategy intact, same, without any change, it may not benefit you much. Nash equilibrium. What is the link? If only one political party fields candidates with criminal past, it may not benefit this political party. Then this political party is odd one out. All the political parties, they should also field candidates with criminal past. Then it is advantage for everybody. Today, whether it is a political party, a national political party, or a regional political party, a big political party or a small political party, they are all the same. In the sense, 39% of the elected MPs in Lok Sabha from the BJP have criminal charges against them. What about Indian National Congress? 49%. What about the regional political parties? Trinamool Congress, 45%. TDP, 50%. The Samajwadi Party, 57%. DMK, 59%. Shiv Sena, 71% of the Shiv Sena MPs flaunt their criminal past. That's why we need this law. Not just that, two important events in the recent past. V. Senthil Balaji. He was a minister in Tamil Nadu under Mr. Stalin. Then he was accused of cash for job scam, allegedly involved in cash for job scam. And then he was arrested and he spent close to 14 months in prison. After a lot of convenience, he still continued to remain the minister. But once there was a lot of pressure, he was dropped from the Council of Ministers. But then he applied for bail, and the Supreme Court granted him bail. On what grounds? Saying that the trial may take several years to complete. Till that time, you are released on bail. And once he was released on bail, he was reappointed as a minister. Matter went to the Supreme Court again, and the Supreme Court now is furious. You may influence the witness in this case because a minister holds an important position, influencing position. You will have to choose. Choose between freedom and post. He chose freedom, resigned as the minister. To prevent such things from happening again, this law is required. Arvind Kejriwal, the then Delhi chief minister, he was accused in excise policy scam. Then he was arrested, spent few months in the jail. And from the jail, he used to run the government. How would you run the government when you are in the jail? If this law would have been enacted, then 31st day, he should have resigned. Or the very next day, he would have ceased to exist as the chief minister. That is why, to prevent such instances from happening again in the future, we need this law. But something else. Section 8 of the Representation of the People Act 1951. A legislator can be disqualified. Let's say the legislator at the union level, parliament, can be disqualified by the president. On what grounds? Change in the nature of citizenship, adjudged insolvent, office of profit, mental unsoundness. On these grounds, a legislator can be disqualified by the president basis the report of the Election Commission of India. But there can be additional grounds for disqualification, and for that, Parliament should enact a law. And Parliament enacted that law in 1951, known as the Representation of the People Act. It has various sections: Section 8, Clause 1, Section 8, Clause 2, Section 8, Clause 3. But if you read newspapers, maybe you will be confused. And I'm here to simplify things for you. You may have heard, you may have read that if a legislator is convicted for 2 years, then he is disqualified, which is not entirely true. It is true, but not entirely true. Why? Because if a legislator is convicted under Section 8, Clause 1 of the Representation of the People Act, even if a fine is imposed, you are disqualified. If you are sentenced and convicted under Section 8, Clause 2 of the Representation of the People Act, and you are sentenced to 6 months or more in jail, you are disqualified. Then those offenses which are not covered under Section 8, Clause 1 and Section 8, Clause 2, which means everything else comes under Section 8, Clause 3, here if you are convicted and you are sentenced to 2 or more years in jail, then you are disqualified as a legislator. Disqualified for how many years? 6 years. 6 years from the release. Which means, for example, I am a legislator and I am convicted by the court of law. If under Section 8, Clause 1, if a fine is imposed, I will be disqualified. And then for the next 6 years, I cannot contest elections. I am disqualified from contesting elections. If I am convicted under Section 8, Clause 3, and I'm sentenced to 2 or more years in jail, for example, defamation. If I'm sentenced to 2 or more years in jail, then for these 2 years, I cannot contest elections. And once I'm released for 6 years, I will not be able to contest elections. I am disqualified. There used to be another provision called Section 8, Clause 4. This section was declared unconstitutional by the Supreme Court in a landmark Lilly Thomas v. Union of India 2013. What was this section? This section said even if the trial court has convicted you and sentenced you to, let's say, 5 years, you're not immediately disqualified. You have 3 months. Within 3 months, appeal before a higher court. Even if the high court disqualifies you, convicts you, you're not immediately disqualified. You have 3 months, appeal before the Supreme Court. And we know the judicial system in India, the cases drag on for years and years, and these criminals who are law breakers, they continue as lawmakers. Matter went to the court. Supreme Court said in 2013 in Lily Thomas case, on the date of your conviction, you are disqualified. You don't have 3 months to appeal before the High Court. No. On the date of your conviction, you are disqualified. Yes, if you approach the High Court and the High Court suspends your conviction, then you can be re-elected. Then you can continue as the legislator. But on the date of your conviction, you are disqualified. So there is already a law which talks about disqualification of legislators if they are convicted. But this 130th constitutional amendment bill is different. It doesn't talk about conviction. It talks about arrest. And arrest is an executive act. This is where there are concerns. Just because you are arrested, the allegation against you is that you are guilty of a crime for which the punishment is 5 or more years. Just because you are arrested, you are removed from the post of the minister. Which means a constable can get you arrested and you will change the will of the people who has elected this individual to the legislature as a minister, as a prime minister, as a chief minister. That's the concern. Ideally, the golden rule of the criminal justice system is you are innocent until proven otherwise. The mere act of arrest does not prove guilt. Instead, it should have been if you are charge sheeted. If you are charge sheeted for those offenses for which the minimum punishment is 5 years or more, then you could have been removed as a minister. But a mere arrest by the police, this seems to be tilting in favor of the union government, union executive, and as such is arbitrary. Why union executive? I'll tell you slightly later. There is no role of judiciary here. In Section 8, Clause 4 of the Representation of the People Act, Supreme Court struck down this provision, role of judiciary. And on other sections, if you are convicted, there is the role of judiciary. Once you have been convicted by the court of law, then you are disqualified. But here it is mere arrest of a minister by the police or investigative agencies, and most of these investigative agencies would be part of the central government, ED, CBI, so on and so forth. Which means that this provision is slightly tilted in favor of the union government. Union government can decide to arrest a minister or a chief minister of a state, custody for 30 days, and on the 31st day, you're gone as a minister, which may violate the will of the people because you're still innocent in the eyes of the law. Innocent until proven guilty. Instead, the provision should have been charge sheeted for serious crimes. You should be removed as a minister. Dr. Abhishek Manu Singhvi says, on the face of it, these amendments seem balanced and non-discriminatory. Because the argument would be, this does not apply only to a chief minister or a minister at the state level or a union territory. This applies to a union minister as well. This applies to prime minister as well. So prima facie, these amendments are non-discriminatory, balanced. But Dr. Abhishek Manu Singhvi asks a question. Can you imagine an enforcement directorate or the CBI arresting the prime minister or arresting the union minister? Which means who will be on the wrong side of this debate? The chief minister of an opposition ruled state, the minister of an opposition ruled state, which may disturb the delicate federal balance of India's federalism. The period of 30 days is arbitrary. For example, you are accused of a crime. The police normally has 90 days to investigate and file the charge sheet. 90 days. But here we are saying if you are in custody for 30 days, you will be removed as the minister on the 31st day. Or if you're not removed, you will automatically cease to be a minister on the 32nd day. Dr. Abhishek Manu Singhvi says this is a ridiculously low period of 30 days and as such is arbitrary and as such violates Article 14 of the Constitution, which talks about right against arbitrariness. but something else. For example, we gave the example of Mr. Kejriwal. What if there is a minister or a chief minister who is illegally detained by the central agencies under a law, let's say Prevention of Money Laundering Act, a serious crime? Look at the data, look at the conviction rate. This is the reply given by the Union Minister of State for Finance before the Lok Sabha. He says that between January 1, 2015 till June 30, 2025, for more than a decade, the department or the Directorate of Enforcement, which enforces Money Laundering Act, it has taken up close to 5,800 cases. Out of these, only 15 persons have been convicted in 8 orders till June 30th, 2025, which means the conviction rate is very low, which means some of these cases at least would be false, frivolous. So, a false, frivolous case filed against the chief minister or a minister of an opposition ruled state will get you arrested for 30 days in custody and gone. And this may then lead to a situation where horse trading will take place, where politicians will cross the floor in lure of money, violating the spirit of anti defection law. So, this law has the potential for misuse, abuse, and overuse, and may be used to deliberately target the chief ministers and ministers of opposition ruled states. And then, is this a red herring, a distraction? Distraction in the sense there is a petition pending before the Supreme Court. You know what the petition is? Once you are convicted, for 6 years after your release, you are disqualified from contesting elections. That's what I told you under Section 8 of the Representation of the People Act. But if you are a government employee and you are convicted for serious offenses, your job is gone. You are not eligible for further employment under the government. But that's not the case with a politician. You are convicted by the court of law, sentenced to, let's say, 10 years in jail. Once you're released for 6 years, you cannot contest elections. But after that, you can. A petition is filed in the Supreme Court that this should be a lifetime conviction, lifetime disqualification. There should be lifetime ban for convicted politicians from contesting elections. The same government which has introduced this 130th constitutional amendment bill in the Lok Sabha, the same government has filed an affidavit before the Supreme Court justifying 6-year period of disqualification. The affidavit submitted by the union government before the court, it says that what is the petitioner asking? The petitioner who is asking for lifetime ban, he says since there is a 6-year existing disqualification period, this 6-year should be construed as lifelong. This amounts to rewriting the law. And rewriting the law, amending the law, is the job of the parliament. Even if you want to review as the Supreme Court, you have the power. You can review, but you can't supplant the law. You can't amend the law by stating that it is not 6 years, it is lifelong. And if you are asking for lifelong ban on convicted politicians, this would be harsh punishment. Maybe this 130th Amendment bill is distraction. The focus should have been on this. Is it not time that we implement this? That those politicians who are convicted for serious offenses, such as rape, such as murder, there should be a lifetime ban for these convicted politicians from contesting elections. That's the need of the hour. Second, candidates with criminal past. Who gives them tickets? Political parties. Instead of 130th Constitutional Amendment Bill, shouldn't the first job be that of a political party? They should stop giving tickets to candidates with criminal past. In fact, this matter also reached the court. The court asked the political parties, why are you giving tickets to candidates with criminal past? Why can't you give tickets to decent ones? Give us the reasons. Political parties replied and said, we are giving them tickets because of winnability, because they have the potential to win the election. That's why we are giving them tickets. Then the Supreme Court said, Justice Rohinton Fali Nariman was the judge. He said, no, you give us reasons why you are giving tickets to candidates with criminal past. And don't tell us that the reason is winnability. Tell us the real reason. Display the entire criminal history of your candidate on your website as well as in two prominent newspapers. Within 48 hours, once you have declared this person as your candidate to contest elections and this person has serious criminal charges against him, display the entire criminal history of this candidate because voters have the right to know. You know what? Political parties have not abided by this directive of the court. They do publish the criminal history of these candidates, but in newspapers which nobody reads. Despite the fact that the court has said you should publish these details in a prominent national and the regional newspaper. Maybe this is the need of the hour. Political parties, the buck stops at the political parties. They should stop giving tickets to candidates with criminal past. Maybe something else. Political parties need to come under RTI. Way back in 2013, the Central Information Commission said all these six national political parties, at that time there were six national political parties, they are public authorities and as such they need to appoint a public information officer. They will come under RTI. These political parties have challenged this CIC ruling in the court. They have decided not to abide by this ruling. That's what is the need of the hour, to bring political parties under RTI. State funding of elections. Instead of receiving donations from corporates, we need to stop these donations and political parties should be given money funding through the election corpus fund, state funding of elections, so that political parties do not receive donations from corporates because otherwise there is quid pro quo. Why would a corporate fund a political party? Because once this party comes to power, they will make rules, policies which will favor this corporate. Ironically, we are a democracy, but that's not the irony. The irony is that democracy is flourishing in India because of political parties. But these political parties are inherently undemocratic. High command culture. Political parties becoming like fiefdoms, family fiefdoms. There is a need to bring in inner party democracy in political parties. That's the need of the hour. So maybe 130th constitutional amendment bill is red herring, a distraction, while as we should be focusing on these important issues. Lifetime ban on candidates with criminal past, bringing political parties under RTI. Political parties should stop fielding candidates with criminal past. What is your take on this matter? Do let me know in the comment section. And if you have liked this video, do press the like button and subscribe to our channel if you haven't yet. I'll see you tomorrow again. Till then, have a great time. All the best.